Go ahead, mate.
You and I were aware from what we saw at around about 10 o'clock when the lawyers for my ex-wife, you and I saw him talking with the police. He actually walked over to it was the first clue. You and I thought, oh, gee, there's something up here. Now that's 10 o'clock in the morning, and we didn't find out till later in the day why the police were there. I think if it was in the first hearing, it would have been about 1:45 that I found out why they were there. And it was only because I asked the judge why the police were there. Otherwise, I probably wouldn't have even been told. And yet, the judge told the lawyers for my ex, and I think that's just biased behaviour on her behalf against me. I think I've got a list of about 11 instances in that particular court hearing alone where the judge showed that she was prejudiced in favour of my ex. If I had more notice, I would have actually got the list with me, so I've got to read it out. But there's that instance. There's talking with the lawyer before I came in the courtroom. One thing she did say when I came into the courtroom, she said, look, you can have a listen to the transcript of what we're talking about if you like, but it still doesn't excuse the fact that he went in there and she listened to what he had to say without me there, and she knew full well I was in the courthouse.
But we've actually asked for a copy of their application.
Sorry?
We've actually asked for a copy of their application and also for that transcript, and we've still not got it.
Yeah, the issue of the transcript, which transcript are you talking about?
This is the one where that ex parte hearing happened whilst she was in court. To do with me, that is.
Okay, I can't remember. I would have put an application for the transcript for the entire court hearing.
Yeah, we just sent in a letter in this instance because we thought, well, she shouldn't have heard that. She knew you was there. There's no reason for an ex parte application. There was nothing privileged or prejudiced to anybody apart from you that would have been discussed.
With just on the transcript side of it, the issue of the transcript for I needed. We actually brought up the issue of the transcript for the 28th of July that I needed for the appeal, and the judge in her order said that both parties will provide her with our notes from that hearing, and she will decide. She was at the previous hearing. She will decide which notes are more accurate.
And we provided our notes.
She gave my lawyer's ex 7 days to submit, and I think she gave me 14 days to provide my notes, which we did. And then we didn't hear a thing. I sent reminders when are we going to have a decision. This court is the appeal can't commence until we've got a decision. And let's see, September, October, November, just almost 4 months later, during the January 14 hearing, we were told that she can't make a decision and a transcript from the court. So immediately, this is in January now, and I immediately sent an email to the court staff asking for an application form for the transcript, and I still haven't got a reply. They are hopeless. Now back to that's what we're talking about, the judge in this matter.
But okay, one second.
Any listeners in Victoria, Australia?
Can you hear me, Keith, or not?
Sure. Yeah.
Yeah. On that point, the reason why we've not pressured them with a new application on that to prove their incompetence is because you're back in Australia at the moment. This is terrible.
Correct, yes. There's no sense in pushing it from here until I'm back in England. So when I first came over to England, I expected to be there 6 weeks, ended up staying 3 months.
Yeah. Okay, mate. All right, carry on.
Just an idea of my opinion of the competence or incompetence of this particular judge is I compare her abilities, and don't get me wrong, she's actually quite a pleasant lady, but I'm not there to be entertained by a pleasant lady. I'm there for a fair and impartial decision. A fair and impartial hearing and a fair and impartial decision. And I put her on a level of competence, for anybody who's in Victoria, Australia, and who's been in the magistrates' courts, she's on a similar level to some of some magistrates that come across, and even so far as judicial registrars. And the judicial registrars only hear minor traffic matters like parking fines, speeding fines, etc. Now, no doubt that in the fullness of time, to use an English expression, she'll get to hear that I've stated this, and I'm quite happy to stand up in court and repeat it. But these judges have got to do their job, and they've got to do it fairly and squarely, and be able to defend what they do, to be able to defend the way they conduct themselves. And in this case, I don't think she should be a county court judge. I think she belongs in the English magistrates' court.
Okay.
Anyway, but at some stage, Bradley and I will put in a submission, and we'll put in it'll either be a complaint of judicial misconduct, or at least judicial incompetence, one or the other. judges, I mean, some of them are just blatant. I mean, how these judges do the things they do and expect to get away with it. I mean, a lot of people obviously don't complain. It's my ex-lawyers because of their disruptive behaviour. I mean, it's just absolutely blatant. You know, if you're talking about street fighting and gutter fighting, well, my ex's lawyers are good, and from that point of view, I admire them. Don't like them, but I admire them because they are fighting hard with tooth and nail and everything at their disposal. I just don't agree with it. During that particular hearing, towards the end of it, I was given a yes, I can.
Sorry, 1 second. You said, unfortunately, your audio cut out quite a bit. You said Bradley taught you to what? Complain? What?
Complain.
Oh, okay, fine.
It doesn't get you anywhere. It's still complain.
Yeah.
Even if your complaint's not going to go anywhere, still complain anyway.
But it's not malicious complaint.
So I do.
Yeah.
No. All you have to look for is their what they're doing, which is unfair, which is unreasonable.
Yeah.
Anything unfair, unreasonable, not impartial, and just put in a complaint.
Yeah, absolutely.
You know, the ultimate complaint is putting in a judicial review, where you go to a much higher court and you have that judge's decision reviewed, and if it's upheld, it goes back to that same judge for a rehearing. At least that's how I understand it here in Australia.
Yeah, no. What will happen is, I mean, obviously, ideally, what you would get is the judge to recuse themselves from that hearing or future hearings. Or what will happen is they'll just get a slap on the wrist.
Yeah, I suspect if they get too many judicial reviews against them that succeed, they'll get more than a slap on the wrist.
But yeah,
and that's why.
The thing is,
that's why I think people complain.
What it basically demonstrates from your perspective is that you're not going to take any crap.
Correct, I agree with that. It's like standing up to a bully.
Yeah, exactly. You know,
and if you look at it from the point of view of bullies, you start dishing stuff back to them, they back down. They start behaving themselves in this case. Hopefully, I think if you put in a complaint against somebody in the judiciary, and even in the constabulary, if you put in a complaint, even if it doesn't go anywhere, it goes on their record. You get enough of them, they're going to be forced to do something about it eventually.
Yeah, you're going to get the police forced to force something on themselves. Yeah.
Yeah, but you could affect their career or their promotion and things like this. You know, I'm sure they look at their records before they promote a judge. And if they see a judge has got abnormal amount of complaints, they're not going to change the way they do things, and they'll cop the same thing on the next level. Yeah, at least that's why I like it.
Absolutely, that's definitely the case. I mean, I've got loads of police complaints in at the moment for people, loads. I think on one incident alone, I think there was 11 police officers which are under review at the moment in one. That's just one case. So it certainly doesn't go in favour of them. The main thing is that you're diligent in your paperwork. On that point, Keith, one thing I think I'm pretty pleased about is how you understand about paperwork now. Your letter writing skills.
I noticed in that last letter that you checked for me, there wasn't a whole lot of editing. I felt really pleased about it. I thought I'm learning.
Yeah, I just added a few bits. That was it. But previously you were writing pages, weren't you?
Probably. You're probably right. Just for the listeners, I've noticed that your approach to court is you write letters that you know with the thought in mind a judge is going to read this letter one day, short, succinct, and to the point, written in a conciliatory manner, not a belligerent manner, and written with in fact you've even got me using this phrase in the letters. In order to assist the court, please can you send, or please can you provide, words like this, and what you've passed on the experience and the results you get from that.
And the thing is as well, what we've also done is where you've got, I wouldn't even say detailed, but frivolous letters from your opponent's solicitors. We've replied back with very, very simple responses. And the reason why we've kept them simple is just so they're perfectly clear for the judge to read, because judges are lazy because of the amount of time they have on their hands. Now, actually, let me correct myself there. They're not necessarily lazy; they just don't have enough time
I think that's more correct.
Yeah, because most of them are very intelligent people, and they don't manage to review the paperwork as we'd like them to do. And also, what does prejudice you as a litigant in person is judges believe actually there's a lawyer or counsel for the other side, whoever it may be, and they think, well, surely they must know what's going on, and they look to them all the time. I don't know if you've noticed that in court as well. You know, they
especially with Lady Justice Roberts in the High Court.
Yeah.
It was mostly a conversation between those two, between her and the QC on the other side. I hardly said a thing, the whole thing.
Yeah.
And it was like as if the less I said, the more I got. Well, and also in the county court level, it was mostly my ex's lawyers doing the talking. At one stage, the judge said something. He started talking, and I said to him, "Look, I'll talk first. It's my case. I talk first." And he shut up 10 minutes.
Yeah.
He actually shut up for 10 minutes. It was like as if he'd been caught with his hand in the cookie jar. He was embarrassed.
Well,
I was sick of it. Just absolutely sick of it. Sick of him. I'm glad. On one level, I wouldn't mind if he's still on the case because I know exactly what I'm dealing with him. Now, with the next time I'm in the county, figure out the new person.
Yeah, he's not the sharpest tool in the box.
By the way, the new solicitor. Yeah. No. The new solicitor for my ex. We've come up with a nickname. I've come up with a nickname for her. We call it Gollum's girlfriend. And I accidentally sent an email to her instead of Brad, referring to Gollum's girlfriend. And she said, I would, please use some decorum and manners in your emails. So I sent an email back saying, "Ma'am, thank you for letting me know that my email didn't go to the right person. And when you start treating me with respect, I will reconsider my decision and with using good manners."
I didn't know you did.
I never got a reply. You can have fun with these people.
Yeah. So okay. So in terms of your letter writing skills and that's it's obviously very important. Pre-court paperwork as well, Keith. I think you've learned about that.
Look, one thing I've learned from you is the bundle, and specifically, and I've never seen lawyers use it even here. Is creating two documents that you've taught me. One of them is called the skeleton argument, which is similar here in Victoria to an affidavit, but it's like no more than 2 pages, and it basically sets out your argument. And if the judge wants to find out more about it, he looks further into your paperwork. And the other thing is using a document that you've brought from the building industry called a timeline. One thing that's been pressed upon me by yourself is no matter every single occurrence that happens during litigation, even beforehand, create a document called a chronology of events. For instance, to give you an example, it'll have, like I do my chronology month by month, and it'll have the top chronology of events March. Then I'll have 1st of March, received a letter from X's lawyers, subject matter, and usually one sentence like subject matter, notes for 20th July hearing. That way I can quickly refer to chronology of events to find out where that letter is and which letter I need to be reading. And then when I create the timeline, which is for the court, I only pick out the events that have happened that I think are useful for the court. You don't need to do it like Bradley, you taught me to do a timeline as part of the court paperwork, not something I keep updated all the time. And when you see these timelines, and if anybody Googles it, they'll see what a timeline is themselves. And it's actually very, very easy to follow. And the idea is to make the job for the judge a lot easier.
Yeah. It's
I've no doubt that Bradley will eventually get the whole legal industry onto timelines.
I'm sure people do them, to be honest.
I'll tell you one thing I've noticed, that Brad and I noticed, is a friend of mine here in Melbourne called Bill. Whenever he writes to anybody in a legal matter, he always puts respectfully. And I've noticed that after several, and I do this now, and after several letters of writing to my ex's lawyers, they are now signing their letters respectfully.
Right.
So maybe the habit will happen over there too.
Yeah. I normally say, "Fuck you very much."
You put that in the words. You don't use those words, but that's the way you've written your letters.
Yeah. No. So at the moment, unfortunately, because you're back in Australia, we've had to get an adjournment for a year now, which obviously can be.
What's happened is that after the 23rd of September hearing, we went back to the High Court once with a very surprising result. We went back, and I actually forget what the hearing was about. This is before Justice... I forget his name now. Anyway, he was a very good judge, and I could tell he was sympathetic. He was trying to figure out how to help me, and he surprised both you and I by saying, well, what you need to do is make an application to the county court to have this whole case moved into the High Court, and here are 4 reasons I'll give you to put in your application. The 4 reasons are...
Yes, I remember that. Yes, yeah.
Implacable hostility, which is what the courts... That's the court term for parental alienation. And anybody who doesn't know what that means, if you've got kids and you can't get to see your kids, you would have heard of parental alienation for sure, but look it up online. It's actually a recognised psychosis. And it's so bad that courts will actually take the children off the offending parent for 12 months at a time or something like that and give the children to the other parent until that parent stops doing what they're doing. It's dreadful. You read the stuff and it's scary stuff what these parents are doing. They're filling the children with hate for the other parent, and very often these children are so young they don't know what's happening. And when I was just about to say what I intend doing when I come back to England, but I actually don't want to reveal this because this will be going on the public record, and I can't reveal this particular tactic before I actually put it into place. Anyway, the 4 things: implacable hostility. Because I'm over Australia, living in Australia, it's an international element. There is potential for... The 3rd thing is potential for contempt of court, which my ex has already been indulging in. I've got several instances. And the 4th one is complexity of case, which you've told me my case doesn't need to be complex, but it's been made complex by the disruptive behaviour of my ex's lawyers.
Exactly
and
right, yeah.
You and I walked out of that court and we could not believe that we had a judge give us legal advice from the bench. We couldn't believe it.
I mean, he wouldn't call it legal advice, let's just be clear.
Yes. Well,
it was off the cuff.
He gave us a suggestion of how to and what to put in the application. Let's put it that way.
I never knew, actually, in family law, international element comes into it. That's one thing I definitely learned. And as it happens, I was in family court, what day is it today? 2 days ago. And one of the questions was about the international element in that case. But but I've never heard it mentioned before, to be fair. But yeah, it's perfectly pertinent in your case. But the judge was extremely helpful.
You and I were walking out on air.
Yeah, I was well chuffed.
Yeah. He was clearly sympathetic, and I would say that in the family court and the High Court, Family Division High Court, that I suspect the judges are chosen because they can be empathetic and sympathetic because of the nature of family law. And there's so many sad situations come up.
Oh man!
And Brad's told me there's a lot worse cases than mine, and I think I've got a bad case.
Yeah, well, I think I've got 3 cases on at the moment, specifically with family.
You told me about a chap on Fathers for Justice website who hadn't been able to see his kids in 8 years.
Yes.
And here I am. If I'd have been able to stay, if I had a visa before I went to England, this whole matter would be sorted out probably within 4 or 5 months. I would have had a contact order in place.
Yeah, I mean, if you had continuous occupation in the UK, we would have definitely had this sorted well by now. Definitely.
Oh, absolutely.
But be that as it may, you're in good standing for when you come back anyway.
Yes.
The main thing is you just keep up with your correspondence with them via post.
One of the things you've taught me is that because my ex, every time I've appeared in court, when my ex is in court, there's more fresh allegations of what I've had. And one of the things you taught me is don't throw any mud back at them. Let them throw all the mud they like, and then hold them to account to prove what they...
Bear with me because we lost that. Basically, what Keith was saying for the listeners is that his ex-wife, I apologise, keeps on throwing new allegations against him, and obviously Keith's getting upset by this, but I'm saying you want her to throw more allegations at you. The reason being it makes her look an unreliable witness to the allegations. Sorry, Keith, carry on.
You're right. Now, I'm not upset about it, although in the last time she put allegations in January, I think it was, I wrote a letter back to a lawyer. I think it was out of court. I wrote a letter back to a lawyer. What else is she going to think of next? War crimes, mass murder? And they're just becoming ridiculous. I mean, some of these things, she's even throwing in you could be saying, okay, if this is true, I'm a bad husband. It doesn't make me a bad father, and it's just nonsense as far as the court's concerned, as far as I'm concerned. So Bradley said, you've said, let the other side throw as much mud as they like, and as you've shown me, and I've said this several times in my paperwork that I believe she is a good mother, but that's as far as I've gone in describing her. Then after the last hearing in the High Court, and I was in the High Court 6 times, and twice in the County Court in 3 months, I came back to Australia, and because there was nothing to do, the County Court order, they ordered CAFCAS in the second hearing to do a more in-depth Section 7 or Section 8 report on risk to the children, to my sons, and that they had 12 weeks, if memory serves, to have that done, which was around about the 16th of December. They had the court report done in that time. I then responded to the lady at CAFCAS. There was a Skype interview with that particular lady. And in the CAFCAS report, I read that she had interviewed both my sons as part of the report. And what I feel is that, and I don't know for certain, but I suspect that my sons were interviewed without the presence of their mum. Because my youngest son said he wanted to see me, which was in direct contravention to what Nikki had told the court. She told the court that my sons had said they didn't want to see me. That was just prior to the January 14 hearing, which was the next hearing, which was set back so long because of the 12 weeks it would take for the CAFCAS report. That January 14 hearing was set while I was in the courtroom in September. And it was the only court date she had available in January. And there was agreement to... and also, I was hoping to be back by then with the visa. It turned out I couldn't be, and they accepted that. And I put in an application to court a few days before, stating that I was seeking an adjournment to a date to be determined, which my ex's lawyers opposed. And part of that was that they were required to respond to me by a particular date before Christmas, and they didn't. I only got it about 7 days before the court hearing. They claimed they'd sent it to me, and when I asked them for the metadata, and perhaps, Brad, you can explain what metadata is, because I'm not quite sure. It's just
the internet trail. That you can track it. To be honest, Keith, I know absolutely nothing about it. It's only that I remember dealing in a court case where the question was raised about the email being sent, and I managed to obtain the metadata. I relied on a friend who knew how to track that. It's just like a chain of custody, I suppose, to prove that actually got sent.
You obviously have to go to the web server or the web provider or something like that.
I haven't a clue how he got it for me, but he got it for me.
And they've probably got the details of when and where it was sent.
Yeah, he got it for me in a couple of days though, and we used it in court. We actually got that case adjourned just specifically for that, to prove the counsel for the other side were lying. And they lied on many occasions. But yeah.
That's one thing I found is that the lies that you hear in court and in the paperwork, and lawyers for the other side will just ignore questions you put to them. Anyway, the January 14 hearing, which I couldn't attend, I sent a request to the court by email asking Craig that I can take part in the court hearing by Skype from here in Australia or through video link via a court in Melbourne. Anyway, I didn't hear anything, so I got heard without me. I found out afterwards that my ex's lawyers had opposed the application for an adjournment and wanted the whole court proceedings to be stopped put on it. There's a legal term for it. Discontinued, yes. Yeah. Anyway, the judge said no and gave me a 12-month stay on the matter, and at any stage during that 12 months, when I come back to the UK, I can then organise a new hearing, and it continues on. Now, that was more than what I'd hoped for. I just wanted an adjournment for several weeks until I could get back. But
So, and also the application that we recently found out, the application we made in December for transference to the High Court is being heard shortly, isn't it? Because we want the whole case to be transferred to the High Court.
Well, I only found out I haven't found out officially because I still haven't received the paperwork that is described that it's being heard on April the 22nd. I've sent an email to the court staff saying, can you send me all the correspondence that you've sent to me, both by post and by email, from the January 14 hearing, because I've received nothing from you. I only received the court order from the January 14 hearing last week, which was just under 4 months afterwards. Now, I don't know what the reason for that was. Either they were very slow in sending out, or they sent the letter by ship, which nobody does anymore, but maybe it got sent by ship. that could explain, but it's only 6 weeks on the water anyway, from what I believe. I've sent an email to them last week. I still haven't got a response. I don't know what it is with court staff, but it's like they don't care.
What's the court order that come to my house? That was the one for the application to transfer to the High Court, wasn't it?
Yeah, well, just very recently, you sent me an email with a copy of a court order stating that it was going to be hearing on April the 22nd this year. Now, all I've got is a photograph of a court hearing, which is a bit hard to read, but I've received no notification from the court myself, and it's my case. They have Brad's address because I was using his address in England, but in the last court hearing on the 22nd of January, part of that court hearing was that all correspondence comes to me here in Australia via email.
But equally as well, if they used my address in April, why did they not use my address in January?
I don't know.
Yeah, well, that's what I'm saying. It's just weird, isn't it?
Oh, it is quite right.
And also,
maybe court staff are being slack. I don't.
Yeah, and also all correspondence was agreed very early on, because I made a point of that should be sent on email. And that was agreed by the judge.
Correct, but on top of that, on the last county court hearing, it specifically stated that for service from now on, because of going back to Australia, would be my email. And her lawyers have actually conducted all their correspondences by email, I must say. There's nothing come by post from them. But from the court, I haven't been advised of this date. You have, and you let me know. I've now got to send a reminder to the court, because it's a so-called paper hearing, which I'd never heard of, where neither party has to turn up. And in the order it says something about because I'm overseas or something or other. Anyway.
Well, paper hearings basically mean the judge will just sit in her chambers and make a decision based on the evidence before her, or him.
Yeah. And this is what I'm not happy with, because there is no evidence. We've only submitted a skeleton argument. Actually, it's probably remiss on our part. We should have submitted all the evidence and all the extra paperwork in the form of a bundle to her by now. I hadn't thought about that, but you've been going through your own crises, so to speak. But I won't go into detail there. So it's not fair to say that you haven't been able to keep me on track. So the next thing to do is to ask for an adjournment until we get this sorted out with the correspondence.
I don't know if you emailed the court about that, or...
All I've done is email the court saying I've received no paperwork from you since January 14, no emails, nothing through the post, except for the court order, the January 14 court order. I only received that last week. Okay,
let's move on then. Since then, Keith, you've gone back to Australia. You're on a reasonable footing for when you come back to the UK, and to move quite quickly in terms of getting access to your children, although it's probably going to be supervised access initially. Because even though there's no evidence.
Yeah, just for your listeners there, to make the decision easier for the court, Brad and I have discussed it, and for the first 3 months, I'm happy to have. I've said that I'm happy to have access to a secure child minding child contact centre.
Yeah, contact centre. Yeah, that's it.
Yeah, and so it should be a fairly easy decision for them to make. I mean, there's 2 hearings in front of me at the moment, not counting the appeal, and the hearings may make the appeal redundant anyway if I get Skype with them through the hearings. But the first one is a fact-finding hearing where the allegations made by my ex, she had to provide by October 14, I think it was, all her evidence. Now they provided that out of date, and none of the witness statements had signatures on them. So I sent an email back said what I disputed, and I said, look, I've got no chance to answer here because they've provided no evidence and provided no witness statements.
Okay, stop there. So quickly. Even though you've got, just so people can understand, and as I explained to you in court, is an unsigned witness statement is a draft document, is not admissible. So that's why you said that.
Correct.
Yeah.
A witness statement requires a signature, and here in Australia, a witness statement, we call them statutory declarations.
Right.
Is if you intend to rely on something as a court document, and this is the truth, you actually have to have it signed by a person of standing within the community, such as a police officer, a chemist, a doctor, usually someone of tertiary education. Or not, that doesn't, but policemen can as well. All they're signing is, yes, I saw this person witness this statutory declaration, and it's similar to a witness statement. But in England, I noticed they're not required to have somebody witness your signature.
No, they're not. No, not ordinarily. Now, Keith, I've got a couple more minutes. We've gone on a lot longer than planned, so I appreciate your time. And I think you've kind of explained stuff. I mean, have you got like a summary or something like that you'd like to provide? And also, just want a couple of minutes more just to talk about what you're doing over there since you've left the UK. So, have you got anything that you can impart in a conclusion or whatever? Or?
As soon as you know, look, what I've learned. I kind of knew it beforehand, but not so much how its application. But when you're in litigation, when you've got a dispute of any that could lead to a legal thing, make what the police call contemporaneous notes. Make notes as you go along, date it, stuff like this. Make the notes as soon as possible. Like you have a conversation with somebody. My friend Bill in Victoria says have a audio recorder on your person at all times. He records everything he has to do with the police and the courts. And he's actually had police back down in court from what they're saying in court when he's produced his recorder saying, well, so if I play this record of our conversation, we're going to hear exactly what you just said now. And he had one copper say to him, well, if you said that's what I said and back down. So record. Always respond to anything you receive in a timely manner. For instance, here in Australia with traffic fines, usually given 28 days. Make sure you respond within that time, so that they can't have a go at you or go ahead and do something. Because quite often in traffic cases, if they haven't heard from you within 28 days, they can take it to the next level. If they had, then they've got to make a decision what to do. I advise the people that I help here. First thing you do when like in the case of a traffic matter, get yourself a ring binder from Officeworks, what you guys call Staples, and start every correspondence. Make a note of the time and the date that you received it. Put it in there. Make a note in your chronology. Create a chronology of events and start filling that in. And that way, when one of the most difficult things, like Brad, you have, and I've noticed since I've come back here, is getting people to get their paperwork organised. It's so hard to follow a case when they've just got a bunch of papers together. They'll explain it to you, but anyway, get your paperwork organised. If you know you're going to court, start work on creating a bundle. And you've got a bundle. The best way to describe a bundle, from what Brad showed me, is just like a book, a novel. You've got a title page, and add to this if I've forgotten stuff. You've got a title page. You've got a contents page. You've got skeleton argument. You've got affidavits. You've got exhibits. Anything else, Brad? I'm sure there's some more stuff.
Yeah. I mean, you can put in position statements, stuff like that.
Position statements. Then when you get the whole bundle together,
timeline.
Yes, of course. Yes, timeline. Not the chronology of events. That's your own reference.
Yeah.
Timeline. And I would endeavour to put. I would even put. I'm not sure if you've told me this, Brad, but I would even put the timeline in as an exhibit, as evidence.
I generally do. To be fair. The reason being, because it's for the benefit of everybody, because it really does help.
Yeah.
When I go into cases, I go in on the basis of that actually my case is a good case, and the person that I'm helping is the one being wronged. For example, if someone would come to me and say I've burgled someone's house, I shouldn't have done it. I wouldn't be involved in that sort of case. All of the cases I get involved in are where someone's been wronged. I have had a couple of people lie to me in the past, and I regret doing those cases. But like I say, I would be open and transparent as best as you can. There's certain stuff I will withhold because it doesn't have any relevance, but the other party may deem it has relevance, but let them request that information.
Another thing I've learned from you is that when it comes to police, don't say nothing. Give me your name and address. If you drive, and show me your license. That's it. Nothing else.
Yeah.
If they're going to book you, they're going to book you. Nothing you say is going to stop them booking you.
Correct.
And whatever you say, they will use it against you. Just recently, when going on a road trip with my friend Peter, I was helping him by driving a unregistered car with a permit from one point to from one destination, from departure from Melbourne to the destination. And because the cars didn't have any plates, we got pulled over twice. And the first time on the Hume Freeway north of Melbourne, right. As soon as the cop saw I got out of the car, took the permit with me, he said, "Oh, yeah, permit, no problem," and he took off. The second time, out in one of the country roads, we got pulled over again. I got out of the car, and this time I remembered, and this is what I teach others, and this is from my experience with being pulled over so many times a few years ago with the police, is get out of the car with the windows up, lock the car. And I told the cop my name and gave him name and address, showed him my licence, and he wanted to know where we were off to, and I told him, and he said, "And what's the reason for the permit?" And I said, I've got to deliver this car. I won't go into detail, but there's only certain circumstances, there's certain things you can't drive with a permit, like social reasons. But that's what he was angling at. And I said, "Look, am I required to answer your question?" He said, "Yes, you are." I said, "No, I don't. You know and I know that I'm only required to give you my name and address and my licence, and show you my licence." And I said, "Look, I'm an advocate for human rights." And I actually said that beforehand. Yeah. I said, "Look, I'm an advocate for human rights, and you know and I know that I only have to give you my name and address and show you my licence."
Do you know, just stop there 1 second. It's funny, actually, you say that. I got arrested not too long ago, again. And I said in the police interview, I'm an advocate for human rights. And I think I actually got that from you.
You did, yes. Yeah. I didn't know that that's what I was doing all these years.
Yeah. And I actually said that in the police interview. Yeah. Anyway, carry on. Sorry, mate.
That's okay. And anyway, he walked off, and I thought, quite often, if you get pulled over on the side of the road, you can be there for 15, 20 minutes. So I said to the guy, as he walked away, I said, "Look, I've got to get going. I haven't got time to waste. I've got a long drive, and I need my licence back in 5 minutes. If I haven't got it back in 5 minutes, I'm coming back, and I'm going to take it back. And if you're going to fine me or arrest me, do it there and then. If you're going to fine me, send the paperwork to me in the mail." He had my licence back to me in 6 minutes.
Nice. Yeah. I've actually pulled paperwork out of police officers' hands in the past. I've just said, "Look."
Sorry?
I've actually pulled paperwork out of police officers' hands in the past, where I've said, no, you're not having.
Oh
that.
Yeah.
I had once a guy I represented. Well, I can't say that. I assisted at a police station, and the police officer was demanding all sorts of stuff in this interview, and he shown him some paperwork, and the police officer says, I need to take that in as evidence. And he went to grab it and leave the room immediately, and he was obviously going to rush to the photocopy, and I just grabbed that out of his hand. And I said, "No, you can't touch that. You know, you've got no jurisdiction over that paperwork. It's his own paperwork." So yeah, rest assured, if it's state documents, obviously they can pull it back. But if it's your paperwork, you can disclose what you see fit, even if it's sitting right in front of you. Especially in like police interview stages, that sort of stuff, roadside. But as I say to people, and you rightly said, if you get a roadside confrontation, is just comply with the basic information, and if they ask you questions, other than you're disclosing your name, your address, your license and insurance, that sort of stuff, just say nothing. It's got nothing to do with them.
Yeah. Me and an ex-policeman in Victoria, here in Victoria, we teach people by role play how to handle roadside chats with the police. And basically, it's you give them your name and address, and they'll start asking you questions, and they're very good at it because they do it day in, day out, and it's very easy for them to get. Just the other day, I saw a very experienced lawyer start answering the questions, and towards the end, when he handed him his license back, the copper asked him another question, and I said to the lawyer, I said, "I would advise you not to answer any more of his questions," and he didn't.
Nice.
And there's three things that coppers will try on you on the side of the road. And this is one of the reasons that me and this ex-copper teach people. You get out of your car, don't stay in your car, with your windows up, lock your car. The reason for that is if they want to search your car, they're going to bust your window, and that's a big thing for a copper to bust because that's breaking personal property. You can make a claim for damages against them, they know it. And I've actually called the bluff on one copper once who threatened to bash the window in with his baton in order to put an unroadworthy sticker on the inside of my car. I had a crack in the windscreen I just copped, and he thought I'd be smart about it, and he gave me an unroadworthy sticker because I wouldn't answer his questions. So there's three things that they'll try on you. They'll ask you questions, and me and David say, am I obliged to answer your questions, or do I have to answer your questions because you don't? And I've had coppers say, yes, you do, and no, you don't. And if they say, yes, you do, I say straight away, and I've said this to a copper, well, what section of what act states I have to answer your questions? And the response I got was, oh, don't talk to me about acts and statutes, acts and sections. Now I'm going to do a roadworthy on your car, and he did. And the only thing he could find was all of my rocker cover, and he claimed that was a fire hazard. And he said, that makes your car unroadworthy, doesn't it? And I looked at him and said, are you trying to get me to incriminate myself? And he stared at me, and he said, I'll let you off with a warning, and that was the end of it. The second thing they'll try on you is they'll tell you to do something. And we teach people to say, am I obliged to obey your order? And that's a little grey area.
Get them to commit. Get them to commit, exactly right.
Yeah, and by the way, you're recording this all the time, just with a little, you know, you don't have to tell them you're recording in Victoria and here in Australia. The law with recording a conversation here in Australia is that there has to be one person in the conversation that is aware it's been recorded.
That is correct. That's
if there's none,
the UK.
you have to get court order. That's what the police do all the time. So the policeman, if he orders you to do something like open your boot, you can say something like, you don't have my consent to enter my car. Because in Victoria, they can only enter your car and do a search if they have reason to believe you committed a crime or a crime is about to be committed, and they have to justify it. And the police know it.
Yep.
And the other thing they'll do is they'll tell you they're going to do something. And there's only one, and it'll be like, I'm going to break into your car, or I'm going to take your car, I want your keys, and I'm going to drive to the police station, things like this. Or I'm going to arrest you, or things like that. I always say to them, you do not have my consent to do that. If they're going to arrest me, I'm going to say, I do not agree to you arresting me, but I'm not going to resist you. And the reason I say that is, these guys have got guns, they've got tasers, they've got mace, and you don't know if they're on a short temper, and you want to get that chat with the cops over as soon as possible from the side of the road and be on your way, because you don't want to hang around a guy with a gun. You don't know what mood he's in. He might be short-tempered.
Well, there's the cop recently in the US shot a man who was running away from him 8 times, killed him dead for a broken taillight.
I heard about that, but that cop has got to be had up on murder or at least manslaughter.
Well, luckily he's got a black judge as well, so he's definitely going down. So it's disgusting.
Yeah.
Listen, Keith, shall we wrap up there, mate?
So there's the three things. Yeah, sure. This really should be the subject of we should have another Skype chat and recording about how to conduct a court case rather than talk about my court case, and go through all the paperwork and how to write the letters and stuff like that, and the reason for writing the letters.
Are you willing to do that with me at some stage? And then we'll because it's better.
I've been wanting to suggest it to you for quite a while.
Yeah, I know you suggested it, but it's better for me to do it with somebody rather than me just talking all the time. And I mean, I've posted a.
My idea was for you and I to do it.
Yeah. Okay. Well, let's do that.
And it's probably best done in where I'm the interviewer.
Yeah.
Because I'm actually from the point of view of somebody who wants to learn how to do it, and you'll answer it like you did with Fabrice, because with Fabrice I noticed that he was asking a lot of questions. There was more questions I wanted him to ask you, but he didn't. Like, there was some points that I wanted him to pursue or get you to clarify. That's what I'd like to see done.
All right. Well, let's do that then. But we just need to get a better connection at some point.
Sure.
I've got a bunch of videos already lined up, which are being edited at the moment, but hopefully I'll get this one put on. I mean, the intention is, to be honest, is just do one a week, or probably do one where there's an interview, because I've probably got a year's worth already, and one where there's probably me doing a topic, because a number of people have emailed me asking to do a little talk video on a specific subject matter. A couple of them I know nothing about, so obviously I can't, but a number of them I do. So I may do intermediary videos where I can just sit there in the morning and do 20 or 30 minutes having a good chat about stuff.
Sure.
There are some other videos on Fabrice's YouTube channel which you can look at as well.
Has he released the second part of that video that you sent me? Where looks like you're sitting on a rooftop or a patio or something.
No, we haven't done the part 2 yet. We haven't.
Oh, okay.
I haven't had a chance to catch up with him. But let's call it. Let's end it there.